With that, I'd like to introduce our first, well, I apologize. One last thing I do need to recognize, and I'll do this again at lunch as well, but we are delighted that, this is not a resource-free endeavor, and so we are very grateful to the sponsors who have helped contribute to some of those resources, including the Antitrust Education Project, and the Antitrust Education Project doing that on behalf of the forthcoming book, The New Paradox. You can pick up this flyer out at the station. It may not have been there when you first registered, so please feel free to grab this. I'll mention some more about that at lunch as well. And then DCI and Consulting and FTI Consulting. So thank you to each of those sponsors and the representatives who are here. Thank you for being with us. With that, I'm going to turn the program over to our first panelist moderator, and he's already been introduced, and that is Judge Douglas Ginsburg, who was appointed to the, or took a seat on the U.S. Court of Appeals for the D.C. Circuit in 1986. Obviously has a very distinguished record. One of the things that we are going to do to keep ourselves on time is not do long bios, but I do want to encourage you to go to the QR code on the back of your program to learn more about every speaker and moderator for the program, including their extensive experience and expertise. One of the things you can also see there is some of their past writings, and there may be additional materials or writings that they've done or scholarship they've worked on that they don't even get a chance to talk about today, but that nonetheless may be of interest to you. We are also very honored that Judge Ginsburg is a regular participant in LEC programs, but even more importantly is a member of the faculty here at Scalia Law School. So with that, I turn it over to the Honorable Doug Ginsburg.
All right, well, I encourage you to look at that QR code. We have a very distinguished panel. Actually, I know many of them are known to most of you, and most of them are known to many of you. I'm going to just set the stage for a moment for this discussion of the Microsoft case. The case was heard en banc from the very outset, and that's been done only twice in the, as far as I can tell, in the years since 1970. That was the Watergate tapes case and the Microsoft case. Now, the reasons for hearing the case en banc from the outset were two, one good, one not good. The one that was predominant in the consideration of the judges, and the one I think was not good, is that it was such an important case. The reason I think, a good reason for hearing it en banc was as follows. We were a court of 11, but after recusals, we were 7. And if the panel divided 2-1, it would be impossible for the full court to rehear the matter en banc, because under the rules at the time, federal rules at the time, that would have required a majority of the active judges, that is to say 6. And so there was no way that any panel of 3 could be reviewed or held accountable by the full court. So rather than remit the case to that lottery, I thought it was a better idea to have everyone involved from the outset. And so ultimately the decision to hear it en banc was unanimous. The case came with a 70,000-page trial record with hundreds of graphical exhibits. One of the parties, you can imagine which, generously digitized the record for us so that it was searchable. That was not possible at the time with regard to the graphical exhibits, however. The challenge of understanding the technology, in addition to overlaid on the challenge of reviewing this record, was significant. And at one point we thought, well, we ought to get an expert in to instruct the judges in some basics necessary to understand the case. But we were not going to do that without informing the parties, in case there was any objection to the individuals that we thought were free of any conflicts. Both parties were adamant in their opposition to that happening at all, and so it did not happen. rather than stir that pot. And so we each undertook as best we could to understand the technology, and I think succeeded. The oral argument began with a claim that this is now Microsoft's claim or argument that I could not dig up the transcript for and give to you, but it's reflected quite literally in the brief itself. Microsoft argued that the license restrictions that it had imposed were legally justified because Microsoft was simply, quote, exercising its rights as the holder of valid copyrights, and that the licenses do not unduly restrict the opportunities of Netscape to distribute Navigator in any event. These licenses were the relationships with internet service providers, IAPs, the OEMs, the array of 5 different relationships that had these limitations. And so the argument began with that assertion, which, in my view, bordered on the frivolous, claiming an absolute and unfettered right to use its intellectual property as it wishes. And I'll quote the brief. If intellectual property rights have been lawfully acquired, then their subsequent exercise cannot give rise to antitrust liability. The response from the court was this. That is no more correct than the proposition that the use of one's personal property, such as a baseball bat, cannot give rise to tort liability. And with that, the argument was dismissed, and that was their lead argument. I don't know who made that litigation choice, but there it was. So, all right, with that, trying to invoke the spirit of the times, we'll turn to the panel for a well-informed discussion of some of the issues that still reverberate through the Section 2 litigation, and we will stay on time. Thank you, and let's begin.
Kick off. Judge Ginsburg stole my favorite quote from the case about the baseball bat, which.
Well, that just shows there was no collusion.
Yeah. So the decision, if you have not read it recently, and I just reread it after many, many years, is really a fantastic demonstration of the court really taking a tremendous amount of time and effort to both set the stage and the context for what was going on at the time, in particular with Judge Jackson's unusual context with the press, but also to really deal with the question, or at least to raise the question about, which I think underlied a lot of the arguments and the decision, about whether technology markets and dynamic effects should cause the court to have a different kind of analysis of Section 2, including monopoly power and tying. In the instance of monopoly power, the court found that there was no need to really think about that differently for technology markets. In the case of tying, the court found that tying cases involving software platforms were really not appropriate for the per se rule, and that was one of the issues that they reversed on and sent back to the district court. I think one of the most interesting things about the case is it's now, as we said, 25 years old, which makes me feel really, really old. But it still is the seminal structure and framework, sets forth the seminal structure and framework for how to think about Section 2 and monopolization claims, both in technology markets and outside of them. And you can see that in the opinion, which sets out the, I know Greg Worden is here somewhere, he used to always say that it doesn't involve balancing, but it's a burden shifting and balancing framework for determining whether or not a monopolization claim under Section 2 is appropriate. And that is really that structure for how you think about analyzing Section 2 cases has really continued to go forward. Whenever you think about Section 2 as a practicing lawyer, I always think about, well, what does Microsoft say about it? We now have the decision that Judge Mehta gave us in the Google case. It actually also follows largely the Microsoft playbook, as did DOJ's complaint in that case. When I first read that complaint, I felt like they were working very hard to fit it within the framework of the Microsoft case. That had been a successful Section 2 case for the government, and I think they really felt like if their likelihood of success would be greater if they followed that framework. So the court goes through each of the many, many ways in which that Microsoft was alleged to have violated Section 2, from agreements, restrictions, all to technology, Java deception, to tying, and does a really, I was going to say workmanlike, but that sounds almost insulting. It's better than that. It is a very structured and careful analysis of each of the restrictions, each of the restraints, what the harm was, what the justification was, and then the balancing if the justification was found to be legitimate. And it ultimately finds and sends back to the court, to the district court, that Microsoft unlawfully maintained its monopoly, that the tying agreement needed to be, the tying claim needed to be redone using the rule of reason, and probably most importantly, and I haven't even mentioned this yet, that the remedy needed to be rethought. And the reason behind the remedy decision was that the Judge Jackson did, I think, two quite unusual things. One was he had these, Bill's laughing at me, unusual being probably a euphemism.
Laughing at Judge Jackson. Right.
He had entertained the members of the press in his chambers periodically to talk about the case before the decision was rendered. But he also didn't allow Microsoft to have an evidentiary hearing on the remedy, which was proposed by DOJ and was proposed that the company be split into two. Microsoft wanted the ability to have a hearing on whether that was appropriate, and Judge Jackson said no. And I think the court, and Doug would know this better than I, but I think the Court of Appeals found that was simply not an acceptable way to handle both the ethical violation with the press, but also not giving Microsoft an ability to actually have an evidentiary hearing around the remedy. And so that sent the case back to the district court, back to DOJ, and the states as well. I was involved in the remedy negotiations and the ultimate consent decree that was agreed to settle the case. The tying claims were never retried, and we worked seamlessly with the states to try to develop a remedial order that addressed each of the issues that the Court of Appeals had found unlawful. We also worked to do something which was, I think at that point, fairly unusual, and that was to have some what we called fencing in relief. So relief that related not just to the allegations that the Court of Appeals had found were violations of the law, but also to try to restrict Microsoft from engaging in conduct in slightly new ways that would effectively have the same effect. I will say I have in my book, we developed the remedy, we put it out for comment, and I have in my office a binder of comments. I think we got 33,000 comments from the public. I don't know if you all remember, there was a period where people were sending arsenic-laden packages to people, and this happened, this seeking comment happened during that period, so we decided for the first time to take comments by email, which I think increased the volume of comments dramatically that we received. Some of them were very funny. So I have a binder in my office of the funniest ones, at least that we pulled out. We did actually review every single one of these comments, and we coded them, and we put them in a database, and then we had to respond to them. It was a lengthy and interesting process. And then there was a whole process that began after that that also went up to the Court of Appeals on the remedy. So that's a quick summary, and happy to pass it off.
Thank you for getting us started. And who did we say would be next?
I think I am.
Yeah.
Thank you, Judge, for inviting me to be here, and thank you to George Mason for hosting this event. I think in getting ready for this event, one of the most difficult things for me was recognizing that it's been 25 years since the Microsoft opinion. I had the opportunity to clerk for the judge that year, and it was really an amazing opportunity to be there and be part of that. Renata's given the overview of the opinion. I thought I would focus just on one aspect of the Microsoft opinion that's generated some heated debate over the years, and it relates to the causation section of the opinion. And different people have interpreted that in very different ways. So in that section, the court wrote, "We may infer causation when exclusionary conduct is aimed at producers of nascent competitive technologies. Neither plaintiffs nor the court can confidently reconstruct a product's hypothetical technological development in a world absent the defendant's exclusionary conduct. To some degree, the defendant is made to suffer the uncertain consequences of its own undesirable conduct," citing Arita. Given this rather edentulous test for causation, the question in this case is not whether Java or Navigator would actually have developed into viable platform substitutes, but whether they reasonably constituted nascent threats at the time Microsoft engaged in the anti-competitive conduct at issue. Now, that passage received a lot of attention from the get-go, and not just because of its use of the word edentulous. Dahlia Lithwick, writing for Slate, published an article in June of 2001 about the DC Circuit's opinion in the Microsoft case. I think the article was titled, "Microsoft Bad, Judge Jackson Worse." And she focused on that use of the word edentulous and had some pretty strong comments about that word choice. But I think a lot of commentators and a lot of plaintiffs seized on that passage in the opinion, not just for the funny word choice, but for really the prospect that it was that it somehow showed that the plaintiff doesn't need to show actual or likely harm to competition in a Section 2 case where the allegation is that the monopolist was targeting a nascent competitive threat. Now, to me, that seemed like a really strange conclusion to reach, because by the time the court reached the causation discussion, it had already said that a plaintiff needs to show actual or likely harm to competition, and had spent more than 20 pages talking about the record evidence in the case that Microsoft's conduct had in fact harmed competition. So I think to level set, it's helpful to take a look at some of the case law leading up to the Microsoft opinion. The Supreme Court had issued a number of opinions in Section 2 cases discussing the need for the plaintiff to show actual or likely harm to competition as a core element of a Section 2 case. So for example, in the Spectrum Sports case, the Supreme Court addressed monopolization and attempted monopolization under Section 2. And the plaintiff in that case said, well, at least in an attempt case, it's enough to show that the defendant engaged in unfair or predatory conduct. You don't actually have to show harm to competition. And the Supreme Court rejected that low bar and held that the notion that proof of unfair or predatory conduct alone is sufficient to make out a Section 2 claim is contrary to the purpose and policy of the Sherman Act. And the Supreme Court held that the plaintiff also must show that there's a dangerous probability that the challenged conduct will result in successful monopolization, harming competition. Similarly, in the Brook Group case, the Supreme Court addressed Section 2. There, the court was focused on a claim of predatory pricing, and the court held that even an act of pure malice by by one business competitor against another does not, without more, violate the Sherman Act. And the court acknowledged that the challenge conduct in that case, predatory pricing, might very well harm a rival. But the Supreme Court noted that below-cost pricing may impose painful losses on its target is of no moment to the antitrust laws if competition is not injured. And the court held that the plaintiff needed to show that the predatory conduct was likely to produce its intended effect, that is, to force the rivals out of the market, and that their exit would then harm competition by allowing the defendant to raise its prices and more than recoup its investment in its predatory pricing scheme. So when the DC Circuit was addressing the Microsoft case in 2001, it wasn't writing on a blank slate. There was already a backdrop of Supreme Court case law holding that Section 2 plaintiffs need to show actual or likely harm to competition. So Renata talked about the case generally. I just want to drill down on what the court said about harm to competition. The court described some core principles of Section 2 case law, and the first one of those was that the monopolist conduct to be condemned as exclusionary must have an anti-competitive effect. And the court explained that it's insufficient for competitors to be harmed. Again, it's echoing what the Supreme Court's already said in Brook Group and other cases. There needs to be actual or likely harm to competition. And the DC Circuit also noted that the plaintiff is the one who bears the burden of showing that required harm to competition. So given how clear the court was, you might wonder how some commentators could read the opinion and come to the conclusion that it somehow dispenses with a need to show harm to competition in a category of cases. In my view, that really comes from just focusing in on the causation section and reading that in isolation without looking at the rest of the opinion or the case law backdrop. The causation section does say that a court can infer causation from the fact that a defendant has engaged in anti-competitive conduct that appears reasonably capable of contributing to monopoly power. And if you do read that in isolation, it might suggest a lower bar, but it needs to be read in context. And the court had already explained that the plaintiff, on whom the burden of proof, of course, rests, must demonstrate that the monopolist conduct indeed has the requisite anti-competitive effect. So the causation discussion was simply explaining that the plaintiff doesn't bear any additional burden of showing that a particular competitor would have been successful in the but-for world. The court did note that more detailed evidence of causation might very well be necessary in connection with remedies. But despite the court's clear language about the need to show harm to competition and extensive discussion of the evidence in that case, plaintiffs, including federal antitrust enforcers, have continued to circle back to that causation language over the past 25 years and repeatedly argue that it lowers the bar. So one case presenting that issue made its way actually back to the DC Circuit just 7 years after the Microsoft opinion, and that's the FTC's case against Rambus. In that case, the FTC alleged that Rambus had tricked a standard-setting organization into adopting standards that relied on Rambus's patents, giving Rambus a monopoly. And the FTC argued that it had met its burden of showing anti-competitive effects because that challenged conduct deceiving a standard-setting body was at least capable of making a contribution to monopoly power. Basically, the FTC was trying to lower the bar for showing a likelihood of harm. And it pointed to this Microsoft language. And the DC Circuit rejected that interpretation of its Microsoft opinion and explained that Section 2 requires a showing of harm to the competitive process, and the plaintiff bears the burden of showing that harm is likely. And the court held that just showing deceptive conduct is not sufficient to show that harm to competition is likely. But that actually didn't end the debate on this. The FTC continued to pursue its view that the Microsoft opinion had set a lower bar. And as I understand the position, it is that the Rambus court essentially went rogue because, as the judge said, the DC Circuit resolved Microsoft en banc. And I think the argument is that the Rambus panel therefore could not overrule the Microsoft en banc decision, and so the FTC continued pursuing its view that the causation discussion in Microsoft set a lower bar and the Rambus court was just wrong. That issue, the general issue of the plaintiff's burden to show actual or likely harm to competition also came up in another case, that's the FTC's case against Actavis, which made it to the Supreme Court in 2013. This wasn't focused on the Microsoft language, but it did deal with the same general issue. The Actavis case involves so-called reverse payment or pay-for-delay settlements in which a patentee pays an alleged infringer to abandon its patent challenge. So these are agreements between competitors where money is exchanged. There's a lot of red flags on them. And the FTC's view is that these types of agreements are reasonably capable of harming competition, and that a plaintiff really shouldn't have to prove likely harm on a case-by-case basis. So the FTC went up to the Supreme Court arguing that there should be a special rule, at least for this category of cases. And the FTC urged the Supreme Court to adopt a categorical rule, just at least in these cases, dispensing with the need to show actual or likely harm to competition. And the Supreme Court rejected the FTC's proposal. As the court explained, the likelihood of a reverse payment bringing about anti-competitive effects depends upon its size, its scale in relation to the payor's anticipated future litigation cost, its independence from other services, et cetera. These complexities lead us to conclude that the FTC must prove its case as in other rule of reason cases. Now, there's some complexities in this case, and the Supreme Court did send it back to the lower courts to try to figure out a path through in this particularly complicated category of cases. But I think it's interesting that even when addressing a pretty unusual form of agreement between two competitors with all of these red flags, the Supreme Court still required the plaintiff to make out a rule of reason case and show a likelihood of harm based on the facts at hand. So in my view, it seems like the Supreme Court's decision in Actavis should have ended the general debate on this issue, but it didn't. Following Actavis, plaintiffs, including the FTC, continued making speeches about the causation discussion in Microsoft and arguing that it lowers the bar for plaintiffs in cases involving nascent competitive threats. Another case where this came up arose in 2017 in a case involving Mallinckrodt. This is a case that I worked on. The defendant in that case owned the only drug in the United States that was authorized to treat a condition called infantile spasms. Acthar, and it uses a product called ACTH to reduce inflammation. In 2013, the defendant acquired the US rights to sell a synthetic version of ACTH that was approved to treat infantile spasms in other countries, but was not approved in the United States. There was a lengthy FTC investigation of that transaction, and it came to light that there was no prospect that this drug would be approved for use in the United States. It was exceedingly unlikely that this drug would ever come to market in the United States. So the FTC could not show that harm to competition from that transaction was likely. But in 2017, the FTC, along with 5 states, sued in DC under Section 2 of the Sherman Act, alleging that the defendant's conduct was reasonably capable of contributing significantly to the defendant's maintenance of monopoly power, repeating the argument that the DC Circuit had rejected in Rambus. That case was filed together with a settlement, so it was not litigated, and the courts didn't address this argument again there. There have also been a number of articles that have talked about this causation language in various cases where it's arisen. Judge Ginsburg wrote an excellent article about this issue in 2020, explaining why this argument is inconsistent with the clear text of Microsoft. Howard has an article on this topic as well, likewise explaining that Microsoft's causation holding is far more limited than some suggest and does not dispense with the requirement that the plaintiff make a case-specific showing of actual or likely harm to competition. So these are excellent articles, but they have not stopped the debate over the causation language. The argument appeared again in the DOJ's search case against Google and in the FTC's case against Meta related to prior acquisitions. I think Howard is going to talk about those more at a very high level. In the Google search case, the district court discussed the reasonably capable language, but also discussed the earlier language in Microsoft, saying that to be condemned as an exclusionary, a monopolist act must have anti-competitive effect, and the plaintiff bears the burden of showing that. There's some debate over how that standard was applied, and that case is currently on appeal. But it brings me back around to the Slate article from 2001 and Dahlia Lithwick poking fun at this section of the opinion and the word choice. It actually seems like the word choice and the concept was pretty fateful. It had some pretty significant consequences over the years. Of course, the Microsoft opinion as a whole has had tremendous influence. It's been cited thousands of times by other courts and articles, generally for propositions that are very clear, but for this one point, I think there's been quite a lot of debate over the years, and I think the causation section is maybe, for the opinion, an outlier in the amount of controversy it's caused. So with that, I'll turn it over to Howard.
Thank you.
Thanks very much, Leah. Is this on?
It's automatic.
Thanks very much. And I do want to follow up on some of Leah's remarks. But I want to note one thing. A lot of people have been saying that the fact that Microsoft is 25 years old makes them feel like they've been around for a while. It was actually 10 years before that I interviewed for a clerkship with Judge Ginsburg, and he declined to hire me.
Was it a fight over causation?
Yes, the but-for cause of my not getting the clerkship were far superior candidates.
I think it was another judge grabbed you.
And on that note, some of my remarks will draw on joint work. Leah referred to an article on but-for causation that I have co-authored with John Nectarline, who will be on the next panel. I've also known John for 35 years because he actually was the law clerk who interviewed me for the clerkship I did get. So very grateful for that, in addition to his co-authorship. So the Microsoft case is fascinating for a lot of reasons. And I think the point at which the Microsoft case landed 25 years ago is actually very important because it explains one of the reasons that I think people have looked at that decision and found so much in it, but often from very different perspectives. And so I want to step back for a minute to the theme of this conference, sort of the state of Section 2. And I think that even by 2000, 2001, when the Microsoft decision landed, there was sort of brewing frustration about the burdens that Section 2 doctrine had, in the view of many, come to place on plaintiffs. We heard reference to Burke Group and predatory pricing. There hasn't been a successful predatory pricing case that I know of since Burke Group, because the combination of the likelihood of harm and the recoupment test placed quite a substantial burden on plaintiffs. So if we think about when the Microsoft case arrived, there was already sort of brewing concern about the plaintiff's ability to win, interestingly, in the context of a case where the government plaintiff largely won. Now, what were the frustrations that were brewing? If we break apart a Section 2 case, we first got a question about market power. You have to get over a market power threshold. And there's been a lot of concern about whether the sort of market shares that a plaintiff needs to show to overcome that initial hurdle are too high. I'm going to put that aside. Interesting, goes back to the Alcoa case and lots of doctrine since then. But then there are two other issues that were really addressed in Microsoft and that I think are a lot of what we're talking about today. Whether conduct is harmful, whether it is the type of conduct that is likely to cause harm, and whether in the particular case the conduct actually did cause the harm. And I want to separate the two of them, because when we talk about rule of reason conduct, which is the vast majority of conduct under all of antitrust, but particularly under Section 2, we're talking about conduct that will have different effects depending on circumstances. In some cases, the conduct may just simply be harmful. In other cases, in other circumstances, there may be offsetting benefits, or there may not be offsetting benefits, but it may have had no harm whatsoever. And so the question that we start to come to in a lot of Section 2 cases is, what does a plaintiff need to show that conduct is harmful, that it was, is anti-competitive conduct, and then furthermore, what is the burden on plaintiffs to show that absent its conduct in that particular case, the market would have been more, absent the defendant's conduct in that particular case, the market would have been more competitive. And it's that but-for standard that I think has caused a lot of discomfort in certain courts, going back long before the Microsoft case, and go back to Standard Oil, where there's this statement that the a burden of proving but-for causation on plaintiffs is too high, impracticable, and one that courts are ill-suited to adjudicate. We see similar statements by Judge Mehta in the liability phase of the Google search case. We see similar language in the briefs that the Justice Department filed in the Google case, saying, well, you shouldn't have to show but-for causation. It's too high a standard. It's unworkable. And one of the sources that is now cited, the Standard Oil language sort of came out of nowhere. And I will just add, it was very peculiar at the time because it occurred after centuries of courts applying but-for causation in tort cases. Centuries and centuries. And courts have continued to apply but-for causation as a standard that plaintiffs need to prove in order to prevail in tort cases. So it's a little bit odd to say as a general matter that courts are ill-equipped to adjudicate but-for causation in an antitrust case, because you can conceive of antitrust as a form of business tort. So why this discomfort with but-for causation? I think that discomfort largely comes from this broader discomfort about the burdens that are being placed on plaintiffs in the Section 2 cases. And it is yet another burden for a plaintiff to have to show that, yep, there was a lot of market power, yep, this is conduct that is capable of causing harm, and in this particular case, the market would have evolved more competitively absent defendants' harm. And so that's where we start to see, I think, the discomfort. And that's one of the things I want to pull apart in the next few minutes and sort of talk about, I think, some of the confusion that has been left behind in the wake of the Microsoft case. The passage that many commentators and some courts have relied on from Microsoft is the one that Leah discussed, the famous edentulous passage. And the argument that is seized on by commentators and some plaintiffs is the following. Well, in Microsoft, having found that there was possibly harmful conduct in the browser market, they said you could just presume harm in the operating system market. But that's not exactly what happened. In the Microsoft case, there was, I'll use the term craftsman-like, work by the en banc panel to identify exactly why Microsoft's conduct in the browser market was not just plausibly harmful, but in fact harmful and not plausibly beneficial. So the conduct that Microsoft engaged in the browser market had been found already to be anti-competitive. And then what the court said is, having acted in a way that we conclude by all applicable standards of, and the plaintiff having proven actual harm in the browser market, we're not going to put too high a burden on the plaintiffs to prove that this spilled over into harm in the operating system market. Having acted anti-competitively in the browser market, Microsoft has to suffer the consequences of a presumption that that harm spilled over into the operating system market. So one way to think about what emerged from the Microsoft case was, once conduct is found to have been anti-competitive, then there might be a reduced burden on the plaintiff to show but-for causation of harm in some relevant market. But that first part is really important. The court had already concluded that the conduct, the specific conduct at issue in that case in the browser market, was anti-competitive. What we're seeing now is an effort to take that passage from Microsoft and use it as a way to reduce that initial burden of showing that the conduct was anti-competitive to begin with. And that is where I think we get some of the confusion that has emerged. You can't take a presumption that already demonstrably anti-competitive conduct was a but-for cause and import that back into the analysis of whether that conduct was harmful to begin with. And so we are seeing a number of commentators, Scott Hemphill and Tim Wu, I think, are some of the most notable ones, who've said, look, we should presume that certain kinds of conduct is anti-competitive because Microsoft tells us that there's really a plausibility standard for whether or not the market could have been more competitive absent the harm. So if it is plausible that a market could have been more competitive absent certain conduct, then we should presume that that conduct was anti-competitive. In our view, that confuses two things. One is the obligation to prove that conduct was a but-for cause of harm. And the other is the standard by which we judge whether plaintiffs have met that burden. And I think that without that kind of separation, we wind up with a misuse of some of the language from the Microsoft case to say, look, if harm is plausibly harmful, or if conduct is plausibly harmful, then there is no obligation on the plaintiff to prove but-for causation. But that is not what the Microsoft case says. But the Microsoft case says if plaintiff has already met its burden of proof that the conduct was harmful in one context, we may reduce its burden, we may apply more of a plausibility standard to that same conduct being a but-for cause in some kind of related, relevant market. Those are two very, very different kinds of analyses. And I think to Leah's point, and if I differ a little bit in your take on Octavius, but this is probably not the time to flesh that out. Courts continue to wrestle with the distinction between proving but-for causation and proving that the conduct was harmful. And the idea that you can import a plausibility standard into whether or not conduct was harmful would frankly upend all of the standard kinds of burdens that I think have developed in antitrust law, particularly in rule of reason cases over the years. So one of the things that we should think about is distinguishing the requirement to prove but-for causation from the standard of proof for but-for causation. If we look to tort law, we can see a number of ways that we might do that. I think that there are social judgments that come into the standard of the burden of proof that we put on plaintiffs to show that there was but-for causation. But I think an elimination of the but-for causation standard is a very risky way to proceed, because you could basically have people be held liable, companies be held liable for conduct that either had nothing to do with the harms that were caused. Now, look, we might think that that is not a terrible problem where there's hard to see a pro-competitive justification for the conduct. But nonetheless, as a typical matter in our legal system, we do not, certainly not in tort law, hold parties liable for harms they did not cause, even if we don't see virtue in their conduct. But when we're talking about rule of reason conduct, single firm conduct, where there can be offsetting justifications, where the business logic can be sometimes a little bit difficult to unpack, there is a potential negative effect, a deterrent effect to potentially competitive conduct, to saying if it could also have had an anti-competitive effect, the burden on the plaintiff is reduced to show that it actually, in fact, did have a harmful effect in the particular context of the case. So I think that the confusion that persists after the Microsoft case is one that I think has real risks for properly adjudicating conduct going forward and actually redressing the harm that occurs. We see some of this, by the way, in the Google case, and I just want to mention a couple of words about the Google case. In that case, Judge Mehta acknowledged that it was very possible that Google's default agreements actually had nothing to do with perpetuating its market power and its monopoly in search. And he was willing to say that there could be liability for the default agreements, even absent any proof that they were necessary to maintain Google's monopoly power. Interestingly, when it got to the remedy phase of the case, the judge did not bar Google from engaging in default agreements for search. And that goes back to the point that I think Renata made, that coming out of the Microsoft case, there is a sense that the standard could be higher when it actually comes to remedies. So sort of an interesting, but if you can have but-for analysis, if you will, for remedies, it's a little bit unclear why the court felt that it felt so uncomfortable and expressly stated but-for causation was too high a standard at the liability phase. It is not. It is a fairly standard kind of burden, and I think that courts should distinguish between whether or not a plaintiff needs to show but-for causation and whether or not plaintiff has met that burden. It's just a final comment. There is an alternative approach that we could take in antitrust law. We could look to the tort doctrine of lost chance, what's often called a balance of harms approach, and say that we are going to impose liability for conduct that only 1 out of 5 times is harmful because we think that that harm, when it occurs, is so great. And that would be a social policy reason to abandon but-for causation, because based on experience, we think 1 out of 5 times there's going to be super harm from, very high harm from conduct, whereas 4 out of 5 times it's beneficial, and we're willing to trade that off as a social judgment. That would be a radical reconceptualization of proof of harm and of burdens in antitrust law, but it would be a more principled way, I think, to get at some of the burden reduction efforts that some current commentators and advocates are seeking.
That would require really exquisite calculations.
Yes.
Okay. Bill?
Thank you, Doug, for assembling the panel, and my deep gratitude to George Mason and its Law and Economics Center and the Law Review for the opportunity, the delight of participating in the panel. Great organizations of all types tend to progress by learning over time. They build upon accumulated experience, they keep what's good, they cast aside what's not, and they make improvements over time. I'm going to talk about why there are features of the U.S. system that make it hard for U.S. policy to learn in that manner and to progress as effectively as it might. There's a lot to learn from the Microsoft case experience. As everybody on the panel has mentioned, there's a lot to learn about the structure of analysis of a monopolization case under Section 2 of the Sherman Act. There's a great deal to learn about how you formulate and prove a theory of harm. There's an enormous amount to learn about case management. If I recall correctly, the Microsoft complaint at issue was filed in May of 1998. The Court of Appeals decision in 2001 was issued in the summer. Was it June or July of 2001? That's barely 3 years from the complaint to the decision in the Court of Appeals. You'd be hard-pressed to find any of our modern monopolization cases that are moving on that track. And the progression of the case in Microsoft was not by accident. There were a number of very creative things done by Judge Jackson, well, until he nearly blew the case up in running the case and the willingness of the parties to cooperate in that process. Why can't we do that again more readily? That's an important thing to learn, I think, from the experience in the Microsoft case. There's a great deal to learn about remedies, that maybe it takes time to see how remedies work. The settlement achieved in the Microsoft case was condemned by many as being excessively timid and a capitulation. The more current view is that it had a positive effect in encouraging entry and expansion by firms, many of which today are the leading enterprises in the field. The hard lesson that it takes time, you might not know right away. You might not know what the score of the match is as soon as the matter itself has been concluded. That's important to know when thinking about the formulation of remedies. Is the only remedy that works the big bang of a breakup, or do conduct-related remedies deserve a closer look? Are they more worthy? And does one need the patience to wait and see whether or not specific results will unfold? These are all extraordinarily important things to learn from the case. And I did, as a sidebar, chuckle when Renata mentioned Judge Jackson's behavior. I talked to lots of the journalists who covered the case. spoke to them somewhat regularly, including those who did speak extensively with Judge Jackson during the case itself. It is my firm view that, and their view, that what Judge Jackson was doing was holding focus group discussions about the evidence. And in one particular instance, the journalist said, Judge Jackson asked him, "Do you think James Alchin is lying to me here?" Alchin was one of the key witnesses. That's not the province of journalists to be consultants to the judge. Had that evidence been before the en banc panel, I think the panel would have said, with regret, you're going to do it all over again. And to realize how close the case might have come to deconstructing is pretty breathtaking. And how could you have possibly modeled that contingency in the future? But I do think it also reveals the awesome pressure that lands on the shoulders of the individual federal district judge. There are other federal district judges who have written about this. We see even in the papers of Court of Appeals judges, such as the members of the panel in Alcoa, how awesome they felt the responsibility of addressing a very important industry in the context of a Section 2 case, how the panel said, we hate this case. We don't like this job. We never would have brought it. We never pursued it, but that's not for us to say here. We have to handle it. But it raises the question about whether the methodology we use to address crucial industrial policy questions is the one that is well suited to the human beings that have to ultimately make these decisions. So there's a lot to learn here. Why do I think our system makes it hard to do so? There are two models you can take to public policy making. One is to accept this cumulative view. Even if you come in a regime change with a different point of view, you can approach the system by saying, I'm going to keep what's good. I'm going to add what I think would be better. I will dispense with what I think has been misguided. But the last thing I'm going to do is look at the institution I've come to and say it's depraved. Or, in the more common vernacular, that it's corrupt, that the individuals are intrinsically failed. The other approach is basically the one that the British brought to Washington in 1814, which is to burn it down. I'm going to burn it down and I'm going to build it up in an image that I find attractive. Here's an example of the second approach. This is President Biden in his famous 40 Years of Failure speech in July of 2021. Over time, we've lost the fundamental American idea that true capitalism depends on fair and open competition. 40 years ago, we chose the wrong path, in my view, following the misguided philosophy of people like, of course, the nemesis, Robert Bork, and pulled back on enforcing antitrust laws to promote competition. If you'd been a rude observer in the room, you would have raised your hand and said, Mr. President, one, weren't you there for 8 of those years as vice president? And did this occur to you by any chance while this was happening? Or did it just come to mind now? The other would have been, have you ever heard of the Microsoft case? Isn't that at least a but-see footnote in your address here? What about that one? It's as though it never happened. And indeed, when you go through the entire Biden era of enforcement policy, you have to look pretty hard to find a senior official who will say, I have to admit, there were 1 or 2 good things that happened during that earlier period, the 40 years. Why has this happened? Why is this painful? It's happened in part because of a considerable change, I think, in the way in which cases are covered. There were other cases that attracted a lot of coverage. Microsoft attracted unusually great coverage. You may recall that sort of midday on the courthouse steps, there was a press conference. At the end of the day, there was a press conference, and we see the development of a conscious effort to build a fan base, either supporting a case or opposing it. And who's the fan base? It's academics. In the modern era, it's bloggers, it's tweeters, who mobilize with great alacrity and sometimes savagery to attack opponents, to go right for their throats when someone will take a contrarian point of view. And to be heard in that environment, you have to turn the volume way up. And if you have sort of a mild observation that, well, maybe it's good, maybe it's not, it depends, you don't get the story. You have to really come up with a cutting observation in order to get likes, followers, in order to do that. That tends to push in the direction more of the burn it down approach than the accumulated process of policy development over time. One thing that I think is difficult, and it's not simply in the Biden comments, you go back over time, the Reagan transition in 80-81 was especially savage in its tendency not to pay any attention to good things that the Federal Trade Commission or DOJ might have done during the earlier period. The transition that takes place into the Clinton era is a bit better. I would say the transition from Clinton to Bush was relatively good. Tim Muris will be on the program at the end of the panel, was very generous in talking about his predecessor, Bob Potofsky. From Bush to Obama, harsher. The candidate Obama said the program of the Bush administration may be the weakest in 50 years. By the way, if you want to draw a comparison, 50 years or half century is always good because nobody's going to go back and look and count. And you get your statement out there and you can run several steps ahead of the follow-up, which again in its own way was painful. We can debate more maybe sometime, Leah, about Rambus. But Rambus was a fairly ambitious effort to address what the FTC was a serious problem. Least effective, least important. Be a little more cautious in how you characterize things. But then again, we have the Biden program. We come to the current Trump era. One of Gail's frequent comments is, "We're not Biden, we're not Bush." And you say, at all? Nothing that you want to borrow from those earlier periods at all? The Biden team was unusually harsh, and the fan base was unusually harsh, going after the throats of those who served in the Obama program. Matt Stoller's famous comment about the Biden enforcers, "They are the worst, totally ineffective and utterly shameless." And this theme is reported again and again throughout the commentary. What do you make of a system that, with most regime changes, goes from being a leper colony to, "I'm the doctor here to fix it"? And now it's another leper colony, and the doctor is here to fix it. It makes it hard for each of those regimes to learn from the earlier experience and to pick up the lessons. There are powerful lessons here. But if you think there's nothing good that happened, then why bother to try and learn from it? The other thing it does that I'll close with is, do you think this is good for our stature abroad? Because there are a number of observers who follow this tendency, and I've heard them say, isn't it interesting in your system that you go through this periodic ritual of condemnation and then revival, condemnation and then revival? Why would I ever trust a country that goes through that cycle on a regular basis, that goes from being depraved to being saved, to depravity to salvation? Why should I trust the system that's so inherently unstable in this sense? You can't count on the institutions to make sensible, self-correcting adjustments over time. It all depends on who's running the show. I will never suggest that who's running the show isn't important. My friends who are fans of Formula One racing say it's two factors, the car and the driver. They're both really important. The driver is really important, but so is the car. And if the car is so ill-shapen that only depends on the driver, who would ever depend on a system like that? I think it makes it very hard in the US system to learn the many things that ought to be learned and absorbed from the Microsoft case. You learn something, inevitably it happens. It's the last desperate measure. You take a look at good things that happened before and maybe you reflag them as your own. But this has become an endemic, I'd say epidemic failure in the US system to learn and observe the importance of the cumulative model of policymaking. And we don't do ourselves any favors by the way in which we think about what's happened before.
Thank you, Bill. Thank you all. We're going to have some crosstalk and then open the platform to questions from the audience. And I'll just start us off, Bill, by asking whether you are suggesting, until your last remarks I was quite uncertain, but I'm now still not entirely certain, are you suggesting that in this wrenching from one moment to the next, that the discontinuity in antitrust is in any way peculiar to the subject matter, or is it quite general across government?
I'd say that the severity of the regime-to-regime criticism has made this a problem across our field of public administration. Yes, that this is, I compare this to my experience in my time, and we have members of the audience who know this much better than I do, so I'm on thin ice, or no ice at all. But I look at my experience being on the board as a non-executive director at the CMA, and the United Kingdom generally doesn't do this. There are harsh moments, but you do not have this severity of criticism. And notably, I think, Doug, when you look at the European Commission, can you recall an instance in which a new commissioner of competition has said, I got here just in time because my predecessor did a rubbish job? They may say that quietly and privately in the background, but they never say that publicly. So I think this becomes an increasingly significant problem in our own system of public administration, because across all of these fields of endeavor, a cumulative process of learning is indispensable to doing a good job. And you can't be as effective as you might be if you don't take that into account.
I think what you're not
I'm not saying the apocalypse is right around the corner, but it's coming.
What you're not seeing at the CMA, you might well see almost any day in the House of Commons.
Yeah, I don't see it. Yeah, I don't have a rigorous proof for this, but I was struck in my time at the CMA that, especially in their competition system, new heads of institutions never stood at a public platform and said, now is the time to trash my predecessor, and I look forward to it as much as anything else.
But Doug, I do think this is a little bit of a new phenomenon. It started, I think, at the end of Obama and went through Biden and has continued on to really, I think Bill's right, to kind of try to burn down the House. And I think part of that is unique to antitrust, because I think the public, Congress and otherwise, has begun to put a lot more pressure on antitrust to solve a lot of economic problems that don't naturally reside in the land of antitrust. And with those expectations, you start, the public servants who are put there by the president feel they need to tell people that they're going to solve all of their problems. And they're going to do that using antitrust. You see that in the Trump administration, you saw it in the Trump 2, you saw that in the Biden administration, a little less in Trump 1, I think, actually. And as a consequence, I think in part what you're seeing is this pressure that's coming from the public policy side of it. It's unable to solve problems that citizens want them to solve through the lawmaking and otherwise, and so they're saying, well, antitrust can do that, and then the antitrust enforcers feel, well, now I have to really show everybody that I'm going to bring prices down, and I'm going to look at the agriculture market, because clearly it's collusion in meat packing that's causing the problem, not tariffs, for example. So I think there is a little bit of this that is unique to antitrust.
Yeah, I think that related to that, Renata, antitrust has been a comparatively technocratic discipline, over the decades. And there's a point at which political moments diverge from technocracy. And I think that's what we've seen. And I think dating to the end of Biden, of Obama is probably a pretty good timeline. But if you think about, let me give you an example of learning and then where that departs from, I think, the moment today. When we came in at the Federal Trade Commission in the Obama administration, we didn't defenestrate those who came before. In fact,
nor did John Leibowitz did not do that.
No, he did not.
Credit John.
And so one of the things that we did was to talk to the Bush people about serious enforcement efforts that they brought and why they thought they failed in court, like Oracle PeopleSoft. And, well, the unilateral effects doctrine just isn't well dealt with in the current merger guidelines. We took that learning in writing the 2010 guidelines to build in a better framework for addressing unilateral effects that would be more rigorous and overcome some of the problems that we, that the government experienced in bringing the Oracle PeopleSoft case and why they lost, in the Northern District of California. But if you read those guidelines, they're they're technical, they have economic analysis, they try to get at these problems through technocratic means. Meanwhile, I think what we've seen, and this gets to your point about solving bigger problems, over that same time, there was just broader concern about concentration, about, there was an anti-corporate sentiment that I think has driven a lot of populism on the left and the right. And then you look at, upward pricing pressure analysis? Yeah, okay, in an individual case, that might help to hold that a merger would be illegal. But it doesn't get at what we all know about how big business colludes, how big business monopolizes. And that sort of sense of we all know leads to a desire to tear down the administration, to say that the small-minded people who came before you were, diddling around in the dark corners. And that's why I think what we saw in the Biden administration was not just dumping on predecessor agency leaders, but trashing the staff, which is, fundamentally trashing the institution because you've missed the bigger picture. It's not overlaps and cross elasticities and upward pricing pressure. It's corporate power. And you're asking antitrust to solve that. You can't do that within the frameworks that have developed. And that's why I think we've seen this hostility.
I would be comfortable with re-examining the approach taken if I was confident that the critics really understood what was going on when they came on. That is, you can have at the institution and its staff, but let's start with a common positive understanding of what took place. And that's what burn it down doesn't let you do that.
Leah, do you see this change over the last 25 years?
Absolutely.
You're in court and you're defending usually.
I am, but no, I absolutely agree with this. You see it, I think it's happening right now, even with a change of guard within Trump too. You're seeing some criticism of predecessors, and so it's very striking. So I agree with everything that the other panelists have said.
I wonder, Howard, whether prior to Leah Khan, the transitions were smoother because the FTC is a collegial body, that is to say multiple heads. So there's some continuity across administrations.
There was, at least to my observation, and Bill has much broader experience across many roles at the FTC, but there was a sincere discussion and cordiality and a desire to really, I think, hear each other out amongst commissioners and amongst bureau directors and things like that, even when there were disagreements. Now, you got a president who just fires the commissioners who might bring that kind of alternative, perspective, and a complete alignment with political objectives. I don't think there's any collegiality. I don't think it's a multi-headed agency. I don't think there's any notion of independence. And that itself is something that sort of breaks that link between, sort of analysis-focused technocratic approach, some of the very things we're talking about in proving likelihood of harm or the burdens of but-for causation. Those are things that require a lot of analysis, a lot of calculation, as you talked about before. That is not the zeitgeist. And sort of having the kind of debate that would generate that and the kinds of nuanced judgments, I do think it's something that suffers in the current environment.
Doug, I don't know how in a confirmation process, in a selection process, you can screen effectively to pick individuals who have an instinct for collegiality and are disposed by personality to do that. John Leibowitz, to take an example, whom I admire. John, I think in many ways, by his own personal sensibilities, but by reason of his time in Capitol Hill, at a time when negotiation and consensus building were important, John brought that approach to being at the commission. That was important to him. And that's a personality dimension. You could have a brilliant competition policy analyst, a superb practitioner, who's just a miserable human being to deal with because they don't accept that norm of behavior. I don't know how to model that. I don't even know how, in a selection process for a multi-member board, how you screen effectively, given the constraints on selection, how you screen effectively to pick people who accept that norm as a condition of operating on the agency. John, fortunately, had it.
Question time. We have 8 minutes. Let's use them well. Alden?
You know,
There's one coming.
Here it comes. This is Alden Abbott, former general counsel.
Alden Abbott from the Mercatus Center and a longtime adjunct at Scalia Law School. Leah brought up the Rambus case, and of course, that was brought as under Section 2, not really as a standalone Section 5 case. So today, most of the panels are about Section 2, but it raises the question, could the commission have argued, oh, we don't need but-for causation anyway, this is Section 5. Section 5 is meant to deal with incipient problems that have not fully been realized, and this is serious enough. They could also brought a deception count. Some staffers wanted, one or two staffers wanted to do that. So again, could that have been, what would Judge Williams have done if it had been a pure Section 5 count? Then you couldn't have relied just on saying, well, but for causation, you didn't do that, go through that, you lose.
Yeah, it's a great question. Yeah. I wonder if it might have come out a different way. I wasn't involved in that case, and I don't know why it was brought in the shape it was. I don't know if others know the backstory.
Yeah. I mean, I can't say what Judge Williams would have done. I know he would have done it brilliantly, whatever he did. But
despite his clerks.
Despite his clerks, he managed to survive us. You know, I do think that would have been a very different case. And, you know, but I will just say this. That was building the track kind of just ahead of the train because we had no precedent under Section 5, right? No one had defined Section 5. So you'd be handing a court an interesting argument, but you'd be asking them basically to make law under Section 5 that didn't exist before, and that's always, even if the law would admit, I think, of a broader approach there. Not so much if they had brought a deception count. I think there was more established track record there. But to bring that as an incipient harm to competition, I think would have been a stretch for the court.
Yeah, I was there. I was the general counsel when the case began. And I think a Section 5 approach, either as an unfair method of competition or as perhaps a deceptive practices case, might have been successful, where if you make the hard assumption that the behavior in question was lying, misrepresentation, generally we don't associate any positive economic benefits from falsehoods and telling falsehood. I'll call it in a rough way the equivalent of horizontal price fixing, which we call per se illegal. If we characterize it that way, and you question whether that ought to work in a Section 2 case too. That is, are there types of behavior that are so pernicious that it changes the analysis of causation? And especially when the remedy being sought is a prohibitory injunction, don't do it again. But let's reflag it as a Section 5 case so we don't tamper with the Section 2 jurisprudence, and we say the essence of the case is it's a falsehood, it's lying, it's misrepresentation. Yeah, I'm giving a sharp edge to the facts here, but say it's lying. And we want an injunction to stop it because it is a business tort that we can pull into the ambit of Section 5. I think arguably it comes out different. Why wasn't it done that way? This has been the historical dilemma for the commission, is how to use that part of its mandate and how to build cases. Yeah.
I think there was another standard setting case not shortly after Rambus, but maybe it was Bosch, I think, maybe,
Yes,
where
it was Bosch.
where Chairman Leibowitz did allude to the fact that maybe Section 5 would be a better way to approach.
But that was filed and settled. He never had to walk the walk on.
No, he didn't. Yeah, but he did
question.
suggest that maybe Section 5 would be a better tool for those cases.
We have a question or comment from Professor Eleanor Fox, who will be our interviewee at the lunchtime program.
Thank you. Eleanor Fox, New York University Emerita. Thank you for the discussion. Thank you particularly for the latter discussion on standing on one another's shoulders that Bill triggered. My question is on causation. And the panel discussion was principally on, here is an anti-competitive act. Did it cause harm to competition? But the unstated question is, what do you mean by harm to competition? In Microsoft, US against Microsoft, Microsoft's sin was that it systematically closed the door to effective entry by any competitor that would challenge its operating system. In Google search, Judge Mehta said, Google has closed the door to the most effective means of anyone else getting to market. Why is that not a harm to competition as a harm to the competitive process? If firms can continually do this act and will never be reprehended unless a plaintiff can prove that output will be limited, doesn't that open the market to huge distortions of competition?
Howard, I think that's for you.
So, Eleanor, I don't disagree that that is something that we should be concerned about. I think the question there is, the question of how we define harm is important, okay? Antitrust typically has, and I think what you're getting at, a particular way of measuring or defining harm. And we at least ask the plaintiff to show that by some measure that is accepted in antitrust law, the market is less competitive than it would have been absent the conduct. I think what you're getting at is something broader, and I think Judge Mehta was getting at this as well. There is certain conduct that you can undertake that might not have actually changed the way the world came out anyway. Like Google closed off means by which people might have a chance at getting into the search market by signing up all these defaults, but even absent those defaults, they might have been a monopolist. That's sort of what he's saying. I think what you're saying is, isn't the reduction of that chance, opportunity, process by which firms can get into the market itself a harm that should be recognized? I don't disagree with that, but I do think that that is a different way of thinking about causation than has traditionally been the case in antitrust. Not that it's something we shouldn't do, it just requires a new way of thinking about how we define the harm and how we think about causation. The causation here isn't you made the market less competitive than it would have been, it's you reduced the chance that the market could have evolved more competitively. I just think that's a policy difference that has not yet made its way into at least the American way of thinking about antitrust law.
Unfortunately, we're out of time. That was a terrific exchange. Appreciate all of you. Please join me in thanking our panel.